jurisdictions across the United States require fiduciaries to have probate bonds. A fiduciary is a person who has an obligation to act for another's benefit, specifically when it comes to management and protection of another person's property and/or money. What are probate bonds? There are many types of fiduciary bonds. The first type include administrators, executors, and personal representatives. These bonds are required when a fiduciary is administering the estate of deceased individuals. Once all of the duties have been completed, the judge will order a discharge of the case, which allows the closing of the bond. Another type of fiduciary bond is guardian or conservator of minors or incapacitated persons. These bonds are only for living wards. These are needed if there is an adult that's mentally or physically unable to care for their own finances, or if a minor child has assets that need managed until they reach majority. What is the required bond amount? Specific bond requirements are determined on a state-by-state basis and enforced by the judges of the court. Agents have the authority to issue clean probate bonds up to $200,000 without seeking pre-approval from their underwriter. Beyond this amount, or if the circumstances of the case are questionable, the submission should be sent in for underwriting before issuing. Circumstances to send the request in for underwriting include no attorney involvement, disputes among interested parties, ongoing business of the estate, the ward is younger than 55, perpetual trusts, pending lawsuits, or if the date of appointment is greater than 6 months. How are probate bonds underwritten? Copies of court documents will often provide most of the necessary information to underwrite. Merchant's standard commercial bond application is used for nearly all probate bonds. Page 1 provides the details of the applicant, bond type, and amount. This page also provides the indemnity of the applicant and possibly their spouse if required. Page 2 includes the required section for probate bonds. The more information provided, the easier it will be to approve the request. Page 3 is a sample financial statement form. Larger bond requests may require this form. What's the duration of a probate bond? Bond requirements are controlled by the court. A conservator-executor bond cannot be closed or canceled unless a court order is signed by the judge. The bond cannot be closed for non-payment of premium or the depletion of the funds in the conservatorship. How much do the bonds cost? Premiums on probate bonds vary by state and type of bond needed. What happens if a claim is filed? All probate bonds work in the same basic way. If the bond's terms are broken, a claim can be made against the bond for compensation. The surety will pay out the claim if warranted, but the bondholder is responsible for paying back the surety in full. How are bonds issued? Those in need of a bond should get in touch with their insurance agent to help walk them through the process. The agent will work with Merchants to issue the bond. Contact Merchants Bonding Company for agent recommendations in your area. Thanks for watching. Please contact Merchants Bonding Company with further questions.